Hey everyone, thank you so much for joining us today for this webinar about different ways to protect your interests as employers. And throughout the presentation, if there is any question, please feel free to put them into the chat, and we'll try to answer at the end of the presentation. And if not, we'll review them and send out an email answering those questions. So first of all, please allow me to introduce myself and my colleague, Alistair, who's here with us today. My name is Junki, and I am one of the employment lawyers here at KSW Lawyers. I note that KSW Lawyers now offers intellectual property services in partnership with the multidisciplinary practice of Moritz Ramsbottom and Forster. And I have the privilege of working closely with Alistair, who is a very seasoned intellectual property lawyer, and it will be our privilege to hear from him in a bit. I will first start off by discussing restrictive covenants, which I hope are in your current employment agreements or exist as part of different working relationships that you may have. And this is so as to limit potential solicitation and competition in the event of termination, okay? And after that, Alistair will take over, and he will discuss other proprietary protections and possible considerations for IP as well as confidentiality in the employment context. So restricted covenants are clauses, essentially, that prevent, prohibit, restrict or limit the actions of a person or an entity named in an instrument. They include confidentiality, non-solicitation, as well as non-competition clauses. Restricted covenants are essentially categorized as a restraint of trade. And in Canada and in BC, it should be noted that there is an important public interest consideration that actually discourages that sort of restraint. However, employers do have a vested interest in including restricted covenants in employment agreements in order to protect the confidentiality of their trade secrets, ensure that they maintain client and employee relationships, and/or benefit from lesser competition in the market. Key principles regarding restricted covenants are well established. However, the case law is constantly evolving, and as such, causes difficulties in enforcing them, at least to a degree. In courts, in determining the enforceability of restricted covenants, they grapple with public interest considerations on the one hand, and the importance of freedom of contract on the other hand. The weight of public interest is such that courts have ruled that a restricted covenant between an employer and employee is prima facie, as a default, unenforceable, unless it is consistent with the public interest and is reasonable between the parties. So in conducting this reasonableness assessment, the court's first step will always be to consider the level of scrutiny to be applied to the covenant. Courts have drawn a distinction between restricted covenants found in employment agreements as opposed to commercial contracts, such as those structuring a sale of business. This distinction is made in the cases between a restricted covenant containing an agreement for the sale of business and one contained in a contract of employment, because a person seeking to sell his business might find himself with an unsaleable commodity if denied the right to assure the purchaser that he, the vendor, would not later enter into competition. Difficulty lies in definition of the time during which and the area within which the non-competitive covenant is to be operative. But if these are reasonable, the courts will normally give effect to the covenant. A different situation is contemplated where a contract of employment is negotiated. Often there is an imbalance of bargaining power, and it may lead to oppression and a denial of right of the employee to exploit following termination of employment in the public interest and his own interest, the knowledge and skills obtained during employment. And as such, the courts will generally apply a higher degree of scrutiny when considering restricted covenants contained in an employment agreement, while applying a lower degree of scrutiny with respect to covenants entered into in other contexts. Once the sufficient level of scrutiny has been determined, the reasonableness of a restricted covenant is assessed in view of criteria presented here on this slide. There has to be a legitimate interest sought to be protected, such as trade secrets, customer lists, or other proprietary advantages that could harm the company or the employer if disclosed to a competitor. Also, in view of temporal length, spatial area covered, and nature of activities prohibited, the restraint also has to be reasonable. And it is very important that the terms be very, very clear. If any portion of a covenant is deemed unreasonable or ambiguous, it will generally be struck down in its entirety. Now, with those principles just fresh in our minds, I would like to provide an example from a decision and go over the term at issue and discuss what the court has said about it. The decision that I would like to discuss is from 2017. It's called the Ceridian Dayforce Corporation versus Daniel Wright. And in here, there was a motion by the plaintiff, the employer, to enforce a non-competition clause. The employer provided software services, and as part of the process, enforceability of the term at issue was discussed. Now, just going to the end of it, the motion was dismissed, and the court did find that the non-competition term was unreasonable and unenforceable. Now let's look at the specific terms that were discussed and are at issue. So first of all, if you look at this term to, I guess, to my left, hopefully to your left as well, it talks about a specific temporal scope, 12 months. The court indicated that the 12-month temporal scope in this case was simply not reasonable. The evidence that was put forward by the employer did not establish the duration of software development cycle or tie this to the duration of the proprietary interest. And because of it, it was really just found to be ambiguous. Second of all, the court actually noted that the term, the term number 2, was actually overbroad for a number of reasons. First of all, when it says in any capacity, the court noted that the term as written would have precluded the employee, hypothetically, from working as a janitor or provide entertainment at an office party. So that was not acceptable. The term also notes that the term covers businesses carried on by the company or any of its subsidiaries or affiliates. Here in this case, the employer actually had many lines of businesses unrelated to the defendant's role. And when Mr. Wright, the employee here, was hired, he just did not have those connections. And because of it, the court found that it was actually unreasonable to prevent him from working in areas completely unrelated to his work with the employer. Now, the court also noted that the geographical scope of North America was overbroad. When the non-compete agreement and the term actually was signed, the employer operated in Canada and in the USA. North America generally includes Mexico and the Caribbean. And as such, the court found that this restriction was unreasonable. The court also noted that and discussed how the relevant time for assessing the reasonableness is the time of the execution of any sort of restraints. With that in mind, in considering the geographical scope, it was noted that it would really be impossible for Mr. Wright to know the number and kind of businesses the employer might carry on during his employment. And lastly, the court noted that this particular restriction about holding 1% or more of the issued and outstanding shares of any publicly traded corporation was just unreasonable. As to how the company came to the 1% or how the company came to this particular restraint was not clear. And because there was no evidence whatsoever, it was simply not in favor of the employer. As you can sort of see, having a reasonable and/or enforceable restraint or restricted covenants is not an easy task. And with that, I do want to provide some suggestions so that you may consider. First of all, you do want to avoid blanket prohibition. You want to individualize the prohibition, and you want to consider the specific circumstances and tailor the prohibition to that individual, so that the likelihood of the term being enforceable than not is actually higher. You also want to avoid unclear language at all cost. If anything, the employee who is signing must be able to understand. And where anything is not clear, then the term will very likely be unenforceable. Now, please note that less actually is more. And as such, my advice would be to focus on those activities and interests that really matter to you. Now, with that, I would like to now turn the time over to Alistair for some thoughts on alternatives and how different proprietary rights may come into play.
Thanks, Junki. And just to repeat what Junki said, please feel free to put any questions that you might have as we go along with anything that we're saying. As Junki noted, I'm a part of Mertzi, Rams, Bottom, and Forster. We're strictly an IP firm, but we work pretty closely with KSW to help provide IP services, especially when they bump up beside employment, litigation, other kinds of services that both of us together provide. Junki, if you could move ahead one slide. So I want to start with talking about the differences between some of the remedies and tools that Junki talked about and how they interface with intellectual property. So a lot of what he's talking about is sort of this post-employment situation where you're concerned about the kinds of information that you might be sharing with your employees, and what can you do to protect those interests, and not even just share it with them, but how can you protect it? How can you feel free to share that information with those employees, which obviously we have to do in order to provide the goods and services that we want to. So if we look at what restrictive covenants do, that's strictly out of an employment law context. So employment law is concerned with protecting employees, protecting employers, allowing people to certainly engage in that type of relationship through contract, but at the same time protecting these sort of imbalances in power that might exist between employers and employees, while keeping mindful of things like competition in the marketplace. IP law is not really concerned with the same policy considerations. Rather, what IP law is mostly concerned about is ensuring that people are free to create things of value to society while being able to share them appropriately as they see fit, and giving them essentially property rights over those things that they create. in a way that would be similar to sort of physical property, but of course, intellectual property doesn't have those kinds of things that allow those types of control that other types of property might. So what intellectual property does is say we're going to provide laws around these things that give people certain property rights. Now, we're not going to be talking about patents, trademarks, that kind of thing, although certainly it bumps up against a bunch of the things we're going to talk about today. Really, I like to look at IP a little bit more broadly. It includes the information that you acquire and you develop as your employees, improve your business, provide the services, while you go out and engage in the marketplace and do things that make you better than your competitors or give you an advantage over your competitors, such as information about your customers, customer lists, market verticals, and potential opportunities, even relationships you may have in the marketplace, in-house techniques and knowledge, methods of doing things, even marketing, people management, business methods. Really, all of those things can be protected in certain ways, with a bunch of caveats, of course, which we'll get into. But all of these things, I think, are things that can be considered in some degree intellectual property, and the law provides certain ways of protecting the people who create that, and businesses who require those types of rights and remedies to provide their goods and services. So, Junki, if you go to the next slide. So like I said, we're going to focus a little bit on, what are the kinds of information that the law would provide remedies and allow you to share. And essentially what it comes down to, unlike the employment law consideration, it really matters what information we're talking about. That's the sort of key metric that intellectual property is looking for. Is it something that's capable of being owned? And if so, is it something that's capable of being protected under the law? And so the case law is all over the place. I would say that one sort of common thread running through it is a lot of the sort of remedies that are associated with what I'll call non-statutory or common law remedies associated with protecting information are employers that perhaps didn't have sufficient protection within their employment contracts, and so they're seeking other ways, other remedies beyond the contractual remedies to assist them. And so what you see happens is an employee leaves, the next day begins communicating with customers of their former employer, and frankly, there's not a lot that can be done in that. A restrictive covenant will protect it, assuming it's reasonable and you meet all the requirements that Junki spoke about, for a short period, a reasonable period, I should say, within a reasonable geographic scope. If it meets all those requirements for a certain amount of time, you can prevent that. In absent that, and absent a reasonable restriction, there's really not much you can do. Intellectual property takes a different point of view on that. So it will consider what are the different kinds of information that are associated. And the courts have talked about a bunch of different types of information. On the left, they won't provide any information, any protection with respect to what some of the courts have called trivial info. And so that's things like useless or public domain knowledge. That's general knowledge, things that are, a business or an individual have no business having a property interest in. As we move farther right, courts do talk a lot about know-how. This is something that courts are very reluctant to put any ownership over. It tends to be information, skill, and knowledge that's developed as part of one's profession or career, or what they do for a living. And so again, the courts are hesitant to put any restraints around that. What's important is that it's retained in the memory without aid of documents. So again, there's nothing really to stop an employee from leaving the next day during the post-employment situation, and really calling up customers and vendors and important relationships. If, however, they took a list and used that, and that was the only way they could contact them all, that would be a different story. I think we'd be more into the confidential information side of things. The only real protection that you have over that kind of thing is restrictive covenants. During the employment period, of course, most employees will have what Junki would refer to as the common law duty of loyalty, which would prevent that kind of activity while they're working for you. And I should say, we're talking about sort of regular employees. We're not talking about a fiduciary relationship. That's something different. While much of these would hold true for fiduciary, and a fiduciary means, a director or an officer of a company, someone who owes an obligation to the company above and beyond even the obligation above and beyond their own interests. We're not talking about that situation, although much of that would apply. We're really talking about sort of a non-fiduciary employee. So moving farther to the right, we're getting into the realm of confidential information. Confidential information has to be something that's inaccessible outside of the relationship, or in this case, the employment relationship. It has to have some sort of degree of originality or uniqueness to it. And that doesn't mean that it has to be created within the company. It just means that that collection of information or the ability or the use to which you put to it has some sort of unique aspect to the company. And I think this part is going to ring true for the rest of what I say. It has to be sufficiently precise. There has to be some element around this that's not mere general knowledge. It could include a recipe, it could include a process, it could include a list. And then next, it has to have, and this sounds unhelpful until you sort of dig into the details, but it has to have an element of confidence around the information. And courts generally provide sort of a list of examples of what that could include. But generally, it's, was it communicated to me in some sort of an element of confidentiality? Was it clear between the parties that this was supposed to be secret? And was the communication, in fact, made secret? If you can show all of those elements, even in the absence of an employment contract, wouldn't recommend this, but there are remedies that are made available. They tend to be things like that are called breach of trust or breach of confidence, and that requires that that there was an element of reliance on the other party to keep information secret, and that element of, or that reliance was known to both parties, and then the other party suffered damage when it was disclosed. So there are some remedies difficult to engage. If, however, the employment contract or other type of relationship for that matter includes sufficient contractual obligations to keep confidential information secret or confidential, then it's absolutely enforceable. Generally outside of the scope of a restrictive covenant. And next, as we move even further right, the strongest type of protection that the law applies to mere information, and that's, we're not talking about again patented information or patented inventions or anything like that, but mere information would be trade secrets. Trade secrets have certain sort of characteristics associated with them that the courts will look to. It has to be a secret. So once it's out in the world, it's no longer a secret. It has to be intended to be a secret and treated as such. So you would have to, put appropriate security measures around it, including in your employment contracts. And it should have some value. And I say should because, it is a little bit context specific, but in almost all cases, they will require that the trade secret has value because it's secret. The good thing about trade secrets, and to me, this is the real intersection between IP protection and protecting this kind of information, being mindful of a restrictive covenant. So even if a restrictive covenant ends up being unenforceable, the trade secret itself lasts forever, and those rights last forever. So if particularly if you can establish the rights through contract, those rights will last forever, and there are a bunch of remedies associated with that above and beyond the ones I've mentioned before. Those also exist. Interestingly enough, with the renegotiation of NAFTA in the past few years, Canada actually has a criminal code. There's a section in the criminal code that protects trade secrets. I'm not sure if that's been engaged, but in theory, you could call the police now, where you couldn't before. The one thing I would say about trade secrets, and actually, if you could skip to the next slide, is that it does have some drawbacks. These tend to be sort of evidentiary ones. The evidentiary issues are, you would be required to prove the existence of a trade secret. You'd have to prove that those elements that I mentioned before, it remains secret, and you've taken reasonable security measures, and that it has value through being secret. You have to prove that. You have to prove that the thing that was taken was the trade secret, and the thing that they're out in the marketplace and disclosing to others was the trade secret. Those are not, without the necessary preparation and forethought, those are not necessarily easy things to do. Generally, your claims are limited to the person who took the information, not the person to whom they gave it to, who received it fairly and openly. And once that cat's out of the bag, you can't get it back in. So it can be very difficult. Now, what I would mention as an aside, I mentioned the criminal code. The U.S. has a trade secret law, which actually, if you acquire a trade secret and it's a trade secret, there are remedies that can be levied against people in the United States. So if this is occurring in the U.S., there are options beyond the ones we're mentioning today. Going back to the pluses, I've talked about the minuses of trade secret protection, but going back to the pluses is, in my view, trade secrets really can be any information that meets those requirements that I mentioned. Actually, if you can just skip back, Junki, just so I can see the list. There we go. As you'll see, these types of information, they're just examples, but it really can be anything to provide its information that you hold within your organization. And I get back to customer list, and I mentioned, and I think it's a good example because, as I mentioned, there are a whole bunch of court cases where the courts struggle generally in the absence of an employment contract, but even if there's no applicable restrictive covenant anymore, an enforceable restrictive covenant, the courts have struggled with providing a remedy for employees simply walking out the door and setting up shop across the street and calling the most important customers. In general, that type of activity would probably not be, you wouldn't be able to stop that under employment law context, and even in an intellectual property one, unless you took the right steps. So these would include the following. I would keep key customers, particularly those that you worked hard to get, particularly those that might be really important to the existence of your business, for example, because they a significant portion of the revenue, or they purchase unique or niche products that you didn't know or wouldn't otherwise be publicly available. That type of information, I would restrict access to that, and I would indicate why that type of information might be restricted for the reasons that I just said. And then I would include in my employees' employment agreements that we're giving you access to certain information, including restricted access to certain customer information that was very difficult to acquire, and we're giving it to you under the context of the employment relationship, subject to all of your trade secret obligations and your confidentiality obligations, simply so that we can carry on business. And if you treat the customer information as a trade secret in that way, then you'll be giving the court a very strong tool to be able to enforce that right, and to be able to say, no, setting up shop across the street with the most important employee that you've taken from them, even though you agreed that it was a trade secret and it was treated as such, there's a strong remedy available to address that type of activity. And I would say that same sort of thought process goes to a lot of these other things, which may not be capable of protection under any other sort of form of intellectual property, and indeed might be your most important assets. Let's skip ahead back to the slide we were on there, Junki. Thank you. So what are the remedies? I mentioned some of them. For trade secrets, there is a remedy of misappropriation of trade secrets. It tends to be mixed up with breach of confidence and breach of trust. There is this thing called a springboard effect, and what there was a case before the Supreme Court of Canada that dealt with Mott's Clamato, which I think only a Canadian audience can appreciate. I never thought I would like clam juice in my tomato juice, but I like a Caesar, I guess. But in any case, the Mott's Clamato recipe was a trade secret, a very closely held one. They did share it with a manufacturer and a distributor who, at the end of the distribution agreement, started making it and selling it because they'd learned the secret. This went all the way to the Supreme Court, and what the Supreme Court said was that was a trade secret. It was protected as such. You basically got an 18 months head start on anyone else starting a new business, because 18 months, and they established this through expert testimony, 18 months is how long it would take a reasonable and competent chemist to figure out, how much clam juice is in there and make their own. And so they granted an 18-month injunction for this distribution company to say you can't sell that until that 18 months runs out. And so you can see that protection was all about the trade secret, had nothing to do, and it was not an employment situation, but you could see that it would apply equally there. The other one is one called inevitable disclosure. This has never been successfully used in Canada. And in fact, when it comes up, the courts generally say things like, we view this as to whether or not it's enforceable in Canada with great skepticism. And I think the reason why is that, for the same reason that courts are unwilling to apply broad and long restrictive covenants, they don't want to stop people from being able to do their jobs or being able to work in the marketplace. And so they're very, very leery of inevitable disclosure. But the other thing I think about it is, in all the cases I've seen, the former employer was unable to point to an actual instance of disclosure of the trade secret. And so what that means to me is that, A, we've had bad facts in support of that. I think that what that means is that there might be a set of facts that might permit a court to say, no, that would be inevitable. We've already seen instances of things being disclosed in this particular situation, for example, and that would require doing a lot of things that I've spoken about. So, making sure that this information is in there, that they've agreed to this, the nature of this information being subject to these types of restriction, and then treating them as such in the day-to-day operation of your business. Now, again, I'm not saying we should rely on the concept of inevitable disclosure at all, but what I do think is that you can set yourself up well to be able to make these types of arguments. The one thing I would say about both springboard effect and inevitable disclosure, when we see it in the case law, is often what happens is that the former employer didn't have appropriate language in their employment contract, or didn't have one at all, and so they're looking to these sort of novel remedies to say, they can't take my secret recipe, or they can't take this list of really key employees, or they can't take this particular method of doing business because I taught it to them and it's really important to my business. But they don't have any other way of doing it. And so that is generally how these things have been discussed in the case law. So whether or not they are enforceable, I think the key take-home message is make sure these things are protected in those agreements from an IP perspective, as well as an employment law perspective. And there's a bunch of pitfalls and traps around that hopefully we're helping you with today. I mentioned the criminal law and the U.S. Defend Trade Secrets Act briefly, and those are just sort of some other remedies that might exist. Again, face the same issues. Was this a trade secret? Is the thing that they took, was that the trade secret? And the thing that they're disclosing and using, is that the trade secret? Those are all become problematic. So if you can go ahead on one slide. So, which brings us to the sort of what are the critical employment considerations for IP and confidentiality? And this is both, I've touched on it before, the sort of day-to-day treatment of that type of information to make sure that you have these remedies available. And I can't stress enough, make sure you have the right clauses in your contracts that that puts these obligations above and beyond sort of common law obligations relating to employment and common law obligations relating to confidence and trust. So one is make sure, again, define the confidential information and trade secrets. And I would say this should be done as specifically as possible. So you may say, you can list stuff within the context of the employment agreement, which I'll get to in a moment. You can list the types of information with some degree of specificity what you believe to be a trade secret. So you can say these types of customer lists, which will only be disclosed in this particular manner, are trade secrets. And part of what we're paying you for is to be able to develop this information and to have access to it, so you can go out and do your job, and you agree to that. So that will go a long way to providing protection over that type of information. Internally, it is identifying and labeling that information. So this can get tricky and it can get a little bit difficult, particularly as we move more to the left of the spectrum that I showed above, with respect to, is this general know-how? Is this general knowledge? Is it know-how that's specific to my company? Is it confidential information that I've shared with you, or is it the highest level of a trade secret? The more you can say, I have this recipe, I have this process, and you can describe it on a piece of paper, and you may never use that piece of paper again, but if you can describe it and use it as a reference, stamp that with a trade secret, label it properly, keep it under lock and key, only give access to those people who need to know, and you can document who gets access to it and how they use it and where it came from. Then you significantly address the evidentiary issues that we spoke about, but also give rise to a practical way of enforcing those rights. I've touched on this already, so I won't get too much in it, but you actually have to take steps to protect that confidential information and trade secrets. If you don't, the worst thing is it ceases to become a secret at all, and there's literally nothing you can do about it at that point, or in most cases. But it needs to, in order to be deemed a trade secret or confidential information by a court, they need to understand that you've taken the reasonable steps to protect it as such. That might mean using, again, make sure your employment contracts and your consulting contracts have the appropriate language. Use NDAs if you're going to share it with people who don't otherwise have a legal relationship with you. You want to educate your employees, so that includes things like having seminars about what you deem to be trade secrets and what your expectations are above them. I would do that early on in the relationship, but I wouldn't neglect to do it once or twice during the course of the relationship. And certainly on exit interviews, for example, I would have an exit interview and remind them of their obligation, which is not strictly associated with at least from a legal perspective, associated with their employment relationship, as much as it is through a contractual obligation they have to keep it secret. And then have the appropriate security and only give information on a need-to-know basis. Again, easier said than done in some cases, but the more you turn your mind to and think about what are the things that I tell my employees, is there a way I can put a nice bow around this? And in terms of a description, in terms of what I share with them, it'll make your life so much easier down the road. When they pop up across the street and they're using your proprietary methods and contacts and relationships to compete against you after working with you for 6 months. Go ahead to the next slide, Junki. So turning to the employment contract itself, in general, I would actually use a separate agreement. I would make it a schedule to the employment agreement. And there's a bunch of reasons for doing this. I would keep it separate from the agreement that addresses things like restrictive covenants, which may end up being invalid, and you have a separate agreement which may survive the invalidity of that. Now, courts may have something to say about whether or not, how far that extends, that invalidity, but certainly I would put it as a separate agreement. There are other advantages to that as well. If you need to enforce it down the road, you're not talking about the employment contract, you're talking about a separate agreement. If you need to, for example, register that agreement because they're being unhelpful with registered IP like a patent, these are the types of agreements that you can use to support that without putting your or their employment contract on a publicly available registry. So a bunch of good reasons I would make it a schedule. I've mentioned some of this before, but I would define trade secrets, what you deem to be trade secrets, and confidentiality and confidential information as clearly as you can, both generally and specifically. So I would say things like, it can be a customer list. It can be, anything disclosed to you under the following circumstances. The more you can do that, the more enforceable and valuable that becomes down the road. Certainly the obligations that are associated with that type of information. So you need, get them to promise to take reasonable steps to keep it secret. They're not allowed to disclose it to anyone who is not part of the company or doesn't, even within the company that have a need to know. Thinking about pre-existing IP or third-party IP is a really important aspect too. So a big part of what we're talking about here is it's not just the employment context, although that's important for controlling that information. But what we're trying to do is ensure that all that IP, including stuff that gets developed by your employees for the benefit of the company, it stays within the ownership or within the four walls of the company. And one of the that's important outside of the employment context. If you are seeking investment, if you are being acquired or you're acquiring, these questions are going to come up around the control of your IP, particularly as it relates to how important it is revenue or your day-to-day operations. And one of the important things is third-party IP, as that sneaks into if that sneaks in through employees into trade secrets or other types of IP that you use on a regular basis, perhaps you lose your ownership rights on that. Perhaps you've inadvertently included something that you're infringing someone else's rights, or you require a license from a third party, or perhaps even worse, someone else has ownership to your IP inadvertently. And so generally what you do in an employment contract context is you make employees promise that they won't do that, but then also list IP that they may be aware of, that they own, that they may be bringing in, or not bringing in, as the case may be, and then require full disclosure if they do that going forth. You want to make sure that it's understood what it is that they're doing when they develop intellectual property, including trade secrets and confidential information of the kinds that we've talked about. That employee created IP is company IP, and they do things like waive moral rights for copyright. There are kinds of intellectual property rights where the creator cannot actually transfer the rights. A company cannot own the rights. An example of that would be moral rights in copyright, and you want to make sure they waive them, so they're not, you're able to use the rights associated with the copyright beyond the scope of what we're talking today. But those are the things that you want to make sure in that agreement. In terms of the ownership and assignment, which is sort of very related to that last part, you want to make sure that it includes an assignment of this information and other IP. It includes the right for the company to file, to take protective steps, including filing registered IP, and to act as their or to give power of attorney to the owner or the company to take steps before a patent office, that kind of thing, as well as the right to assert all of the rights that arise. And I've said this before, we really want to have an acknowledgement that the development that they'd be doing, the ownership, the requirement to transfer that ownership and to do the things like sign assignments, like assist in speaking to patent examiners, that kind of thing, is part of what you've employed them for. Part of their consideration, their remuneration, is for creating things. It's for being creative, and it's for helping the company acquire rights on that. If it wasn't for that, you wouldn't be hiring people. And so when that's clear in the employment contract or the schedule to the employment contract, and it really gives courts, an idea of what's fair to enforce. And then lastly, I want to talk about post-employment. So post-employment, we need to make clear that these rights survive after the termination of employment agreement. Specifically around the trade. Well, I would put it for much more than this, but I would specifically point out for the purpose of this presentation that we need to refer to the trade secret and confidential obligations. Confidential information obligations, and the fact that those obligations could potentially last for as long as the information remains secret. And then lastly is an agreement to assign or to assist. I already mentioned that earlier, but I have been in situations where we have to reach out to employees long after they've left the employment relationship, and they don't want to, but we have a contract in place that they agreed to do that. I should say most times they don't care, but I have been in a situation where former employees don't want to assist, and we need a signature, or at least it makes it much easier and more routine, and those types of requirements are key to that. And I would also say, again, going back to the due diligence sort of thinking about, during acquisition or investment, these are the types of clauses that might be picked on by opposing M&A counsel to say you don't own your IP, and this IP is crucial to the business model. So these are important things to get, particularly in your standard employment contracts. Do you want to go to the next one, Junki? So that was kind of all we were going to say on proprietary information, like trade secrets and confidential information. We did want to mention that there's particularly in BC, particularly recently, some of the activities that would look at and review this type of stuff is actually funded by BC government. You have to apply and you have to go through appropriate steps. So, for example, AccelerateIP, it's a program of the BC government. You have to participate in an education piece. This doesn't count, unfortunately, but there is an education piece that's approved. You have to engage in some sort of level of mentorship. But once you've done that, and they'll, you apply for that, and they give you the appropriate contacts to be able to get that. You can apply for IP strategy supports for up to 25K, and that's IP strategy support is sort of development of strategy. It's making sure your employment contracts are up to snuff. It's making sure, potentially doing things like, patent searches to see who else out there is doing what you're doing. And then IP implementation, that's paying for patent applications, trademark applications, trade secret agreements, that kind of thing. Although the L2 or the IP strategy supports, that's where you would do things like IP audits to assess how you're treating IP. The point being that 75% of that is reimbursed. So, you can get investments of up to 100K, and as long as you put in a little bit of skin in the game, the government will reimburse 75% of it. That's BC. If you skip to the next slide, there is an IRAP or a federal government. It's called IP Assist. That's requires a little bit more hand-holding, but it's also, I think, more broadly available. There are some eligibility requirements on the BC AccelerateIP for the BC government one. Generally about the stage of company that you're at is usually what they're looking for, whereas IRAP, it's a little bit more broadly available, but there's more overhead and more hand-holding. So, but those are the three stages. They're similar. The amounts are a little less. It's limited to mainly strategy and IP audits, but it at least gives you some significant funding to get the kinds of things that we're talking about today paid for, and then have a roadmap for protecting your IP, whether that's trade secrets or whether that's patents and trademarks and other forms of intellectual property. So those are the big things I want to talk about today. As lawyers, we always throw these in our slides, but this is pure information. It's really just to help you think about some of the topics and issues that can help you as you move forward with your business. if you have specific issues, I'd ask that you reach out to one or both of us to talk about them. With that, I'd like to ask if there's any questions. I think if anyone wants to jump in or type something in the group chat, I'm happy to. We're both happy to answer that. Junki, I have a quick one.
Yep.
And I touched on it, but I'm an IP lawyer. I'm not an employment lawyer. So I just, I brought up the duty of, and I talk about it a lot, but I think you understand it a lot better than I do. The restrictive covenant, that's post-employment. Can you talk a little bit about the duty of loyalty that an employee has? Like, can they go across the street and use that type of information?
I think it really would depend on the employee, really. So intrinsically, there's what's called the implied duties when it comes to employment relationships. So employers and employees, they both have respective obligations and duties, and they include duty of fidelity and confidentiality. It's just that how to actually play out in a real sense, that's something that we will need to look a bit into and look a bit into different obligations and positions that the particular employee may hold at a given time and in place. But my preferred way of going about it is just to have it all written down in a contract so that it actually is clearly understood and clearly I guess conveyed. But there are times where contracts are drafted in a poor manner, and that's not really helpful. But those are some of the things that you want to really be thinking about. And what's really difficult is that it is very case specific, and as such, it is advised that you consult and see what's actually appropriate for a given business and for a given employee. Oh, there actually is a question in the chat. I think this maybe for you, Alistair.
Sure.
Question
Yeah.
is, how does trade secret protection work internationally?
Yeah, and I just to follow up when you said thanks for that.
Yeah.
I totally agree. It needs to be written in a contract. And I think these post-employment obligations with IP, because they last forever, it really is something to supplement those types of protections. So, which brings me, thank you for the question. For like I mentioned, intellectual property, it's not a physical thing you can hold. It's not the control over these things is much different than than physical property. So how does it work internationally? So the one good thing about trade secrets is that you're not required to register it. You don't have to tell any governmental authority, unlike a patent or a trademark registration. They exist by virtue of being secret, and if you take the right steps, they will stay that way. Now, it does rely on the laws of the country that in which you're operating or sharing those that information with, which again may have very different employment law considerations. But trade secrets, I will say in general, most country, and the same reason we had to change our criminal code, we belong to a bunch of treaties. Certainly the US has very strong trade secret protection. Most European countries have very strong trade secret protection. Most Asian countries have very strong trade secret protection. Some jurisdictions the enforceability can be deemed as a little bit selective, but certainly US, I would say, stronger than Canada. They have very strong trade secret protection. Europe for sure. And really, as long as you meet those requirements, then you will have a claim to those. Now, it raises the important question: if you're sharing information, to an international customer or a relationship, you'll need to make sure that the disclosure is kept secret under that country's jurisdiction or their laws, excuse me. But there absolutely are remedies available across borders, and you don't other than maintaining the same types of protections and security measures as you would in Canada, they would still apply.
Well, I'm not seeing any more questions, but if you do have any specific questions that come up eventually, please feel free to reach out to either me and or Alistair directly, and we'd be happy to discuss further. Thank you for joining us, and we'll now close the presentation. Thank you.
Thank you, everyone.